Hello and welcome to Health Affairs This Week. I'm your host, Jeff Byers. It's October 2nd, 2024. Today we will be talking about PBMs and their lawsuits. Before we begin, I wanted to share that Health Affairs has a new research collection page that was published this week that focuses on health-related research on issues going into the 2024 presidential election. Fret not, it's not a divisive engagement bait scare tactic. It highlights the nonpartisan nature of health affairs and collects recent journal articles, theme issues, podcasts, and forefront articles on drug costs, antitrust and markets, food security, and financial stability. We will update this page to include more research on the Affordable Care Act and reproductive health in the coming weeks. I'm legally required to tell you to check it out in the show notes. Today we have on the program, back with a vengeance, Chris Fleming, our very own Health Affairs Chris Fleming, and from Washington University in St. Louis, Rachel Sachs. Rachel and Chris, welcome to the program.
Thank you. It's good to be here.
Likewise.
Fantastic. So we know the FTC released a report on PBMs, pharmacy benefit managers, for people not up to date with their alphabet soup. Later, the agency sued some PBMs over insulin prices. Rachel, can you give us a little overview of this case?
I'd be happy to. And as you mentioned, the FTC in July released this interim staff report on PBMs. For those who may have missed it, you had Stacey Dusetzina on this podcast to talk about that report. She gave a great overview, so I'd recommend that to listeners who maybe didn't get a chance to take a look at that over the summer. But as to this case, the FTC's primary argument is that the three largest PBMs, right, CVS Caremark, Express Scripts, and Optum, have violated the FTC Act, including through their business practices of preferring to include on formularies insulin products with high list prices and high rebates, as compared to similar low list price insulin products that have lower rebates. And as you mentioned, the complaint is focused on insulin, and it articulates the ways in which PBM practices, in the FTC's view, have harmed competition in different ways. So first, by discouraging the introduction or the utilization of these lower list price insulin products, there are a number of specific allegations in the report about manufacturers trying to introduce lower list price insulin products and basically being rebuffed by the PBMs who were not interested in putting those products on their formularies. And then it also alleges that the PBM practices harmed consumers whose out-of-pocket costs are based on the list prices, and that in some cases that led to patients paying out-of-pocket costs more than the amount their insurers were paying for those same products. The complaint is not focused primarily on pharmacies, which the interim report was. It's just focused on the PBM's relationship with the insulin manufacturers and with insurers.
So you mentioned the report that came out earlier this year. One of the things that people commented on when that came out is that the FTC seemed to be pretty unhappy with the responses it was getting from the PBMs. It was looking for a lot more transparency than it seemed to be getting. Is this suit sort of following on that? Is this a way of turning up the heat on the PBMs and saying, look, we're serious about this?
Well, arguably the heat was already pretty high. So, of course, there's this lawsuit, but there's also been lawsuits that have been brought by a number of state AGs, attorneys general, against the PBMs, specifically alleging unfair or deceptive acts or practices in the insulin context. So, as you noted, there were these questions about whether the PBMs have, in fact, submitted the information that the FTC had asked for before the interim staff report was released. And so one possibility is that the FTC looked at the information that it had and sort of was able to move forward based on one particular case, but is still building a record on some of those other claims that are introduced or explained in that interim report.
And so we'll talk more about the suit itself, but you mentioned that the heat was already up on the PBMs. One of the places that the heat has arguably been up is on Capitol Hill. The House passed PBM reform legislation, I believe, at the end of 2023. It didn't make it into law, but there's been a lot of hearings, a lot of bills introduced following on that. it seems to be, bipartisanship is in short supply these days, but this really seems to be an issue that excites both Republicans and Democrats. What do you see happening in the lame duck session after the election and beyond?
Yeah, I've never been very good at making political predictions about what will pass through Congress. But as you suggest, there are reasons to be optimistic about the potential passage of legislation. So, as you said, the House passed this particular piece of legislation, which had a lot of transparency elements in particular on a somewhat bipartisan basis. So, there's a lot of reason to think that it could be included in an omnibus or appropriations package closer to the end of the year. It might depend on the particular priorities of the various legislators and what they're engaged in at the time. On the other hand, this effort has been in the making for quite some time, as sort of we've just suggested, and it hasn't happened yet. So some people might say you shouldn't bet against the status quo as the most likely outcome. But especially as we're seeing the interim staff report, this complaint, we've now seen members of Congress praising, or, specifically, I saw a note from Senate Finance Committee Chair Ron Wyden expressing support for this lawsuit, encouraging the agency to continue its work in this area. So you might imagine, right, that there will be even increased support from what there already was.
Well, on the lawsuit itself, coming back to that, what do you see? And obviously, it's what do people say? It's hard to predict things, especially the future. But what do you see as the outcome there? What sorts of remedies might we see, and might those affect PBM practices? Certainly with regard to insulin, but also more generally.
Yeah, and I really appreciate the question about remedies in particular, and I want to answer that directly, and to talk about the lawsuit, but also put it in this broader context. So this lawsuit is an administrative complaint. FTC is filing this complaint under its own administrative process before an administrative law judge rather than filing a lawsuit in federal court at this time. And the complaint identifies August 27th, 2025 as a date when an evidentiary hearing will be held on the topic. But I've already mentioned these state attorney general lawsuits that are moving in parallel, been filed by multiple states, several of which have been filed sort of more than a year ago. So you might imagine that additional information will come out in the course of those lawsuits that might be relevant to the progress of this case as well. And so you can imagine the PBMs taking different strategies. So I remember a couple of years ago, there was this string of settlements by Centene's PBM relating to state Medicaid programs and their allegations about Centene's PBM engaging in certain spread pricing activities. And there were settlements in those cases. So one option here is for the PBMs to try to settle the cases and either provide financial remuneration or agree to conduct-based terms. And so the remedies here that the FTC is asking for are interesting to look at as to whether they would address some of these issues. So one of the remedies the FTC has asked for is to prohibit the PBMs from accepting compensation based on a drug's list price. And it happens that federal agencies or state AGs can reach settlements that are not just financial, but that include conduct-based remedies of this type. And it's very possible that we could see something like that here as well.
Just to sort of expand our focus a little bit on when it comes to the lawsuit, I remember reading there was a press release that came out when the FTC filed, and they said that they've used their discretion to sue just the PBMs and I guess their associated GPOs to not include the manufacturers themselves, the folks that make insulin, even though arguably they've raised their prices sort of to go along with this game, with the PBM seeking higher rebates. How do you see sort of that aspect of things? And is that a shot across the bow? I mean, obviously there's been a ton of action on the drug price front. And we just had the first 10 drugs announced in the negotiation program. What did you make of that comment?
Yeah. And so here it does suggest that FTC has a lot of information about what might be going on here. And some of it could be used, they're suggesting, to bring a case against these other actors, right, including the manufacturers themselves. One thing that makes it challenging to read the complaint is that significant portions of it are redacted by nature. That's not unusual. And so it can be tough sometimes to figure out sort of exactly what the manufacturers are saying, what the PBMs themselves are saying. And it would be very interesting to know what some of these comments that are blacked out are and whether they would be supportive of a lawsuit of that type.
Well, just to sort of go for a second, just a little bit behind the scenes, or maybe sort of legal trivia, but there have been a couple interesting things about this suit. One is that it was filed, I guess, under Section 5 of the FTC Act, not under the Sherman Act, and that they chose to file an administrative court rather than going into federal court. Do you think any of that is significant? And I know there was the Supreme Court case the last term that limited the extent to which the agencies could use their own administrative procedures. So what do you make of those aspects of things? Is there any way to tell how that's going to play out?
Yeah, the Supreme Court case from last term about use of sort of internal administrative procedures is one that I know I would bet that a number of federal agencies are thinking critically about and trying to figure out to what extent it might apply to their own proceedings. And we don't yet know what the courts will say about its extension to some of these other agencies and other types of procedures. So there's a lot of people staying tuned and watching to see what's likely to happen there. You're right to point out sort of the interesting fact that this case is being brought under Section 5 of the FTC Act, which is primarily about unfair methods of competition. And that's sort of a broad concept. So in theory, right, you could imagine a whole range of things as falling under that description. And the states that are bringing these other lawsuits are typically doing so under their sort of related statutes, assessing or arguing that there's unfair, deceptive acts or practices is the way that it's often put. And so that's related to the ways in which the complaint is framed, right? It's not necessarily alleging, that the manufacturers got together to price fix, right? Or that there's particular conduct by an individual person that's monopolizing the market in some way unlawfully. The claim is rather that there are these unfair methods of competition in terms of their relationships with manufacturers and with insurers that have these harms to competition and to patients.
Well, fantastic. As we wrap up this conversation, you mentioned that it's not always smart to bet against the status quo. No one ever got fired for subscribing to health affairs for their institution. So as we think about that, as we mentioned, that he's been on PBMs for quite some time now. So this is more of a two-part question, but what can we actually and truly expect for reform in this space? And what makes this moment different?
Yeah, and one point maybe I'd make here is to really think carefully about what we mean when we say PBM reform. Because one thing we might mean is that we're thinking about a result we're seeing that we are concerned about, and you could address that through a law or regulation targeting the PBM. But maybe you target another entity. And here's an example of what I mean, right? So one of the primary concerns in the FTC complaint is about the ways in which patients are being harmed as a result of some of these practices by being exposed to these high out-of-pocket costs based on the list price of the drug. But you might think that not just PBMs, but also insurance companies have a key role to play in designing insurance plans that don't expose patients to these out-of-pocket costs. And so you can look at, for example, the Inflation Reduction Act, right, passed in 2022 under President Biden. I should note here for full disclosure that from April 2023 to April 2024, I served as a senior advisor at the Department of Health and Human Services Office of the General Counsel in the Centers for Medicare and Medicaid Services Division. I'm fully back in academia now and excited to talk about the way that the IRA caps Medicare beneficiaries' out-of-pocket costs for insulin products, right? People know this at $35 per month. So it's less critical what the list price is if the patient is only being asked to pay this flat copay. Similarly, right, the IRA redesigns the Medicare Part D benefit. It creates this out-of-pocket cap for patients in general. It insulates them from some of these really high coinsurance payments. So even if the PBM's preference high list, high rebate products, by enacting reforms that target the insurer rather than the PBM, you may have engaged in something we would otherwise call PBM reform, where I'm putting quotes about that and recognizing that a podcast is not a visual medium. You're protecting the patients from the harm that you had observed, right? I'm oversimplifying slightly in the interest of time. I also don't think people should ignore what's going on in the states. So one thing to note is that states have a difficult time regulating insurers because of something called ERISA preemption, which is everyone's favorite topic. But states may have an easier time regulating PBMs under ERISA, particularly after a 2020 Supreme Court decision. For those who want to read more about that, I would point you to a Health Affairs Forefront piece by Erin Fusey-Brown and Elizabeth McCuskey. It's called The Implications of Rutledge v. PCMA for State Healthcare Cost Regulation. And this is to say that I'm optimistic about the possibility of reform, both because we may not be limited to potential reforms that need enactment by Congress on the federal level, and because we can think about regulatory and statutory reforms that don't act on PBMs themselves, but that affect the incentives of other key actors in the healthcare space to push back on some of these results that the FTC is concerned about.
It is heartening to hear that after your time in government, you have emerged optimistic.
I always was.
Well, Rachel Sachs, Chris Fleming, thanks for joining us today on Health Affairs This Week as the only non-lawyer in this recording session. This is a great conversation to hear about the latest FTC lawsuit with PBMs. To you, the listener, thanks for listening to Health Affairs This Week. If you enjoyed this episode, please share it with the Oasis fan in your life. They'll probably need something while they wait to try to purchase tickets. Subscribe and look forward to seeing you next week.